Evening. Welcome back to our live Q&A. We're still on child maintenance questions part 2. We'll move to part 3 later when we will be dealing with more complicated issues like appeals and so on. Thank you for joining. I'm waiting for a few people to join us. The format is as follows. Feel free to pose any questions you may have on the issue concerning child maintenance. I've noticed that quite a few people post questions just before we end, but I think Facebook takes some time to let the questions appear on my side at least. Therefore, I ask of you please to pose your questions as soon as possible. I am only taking questions or answers, providing answers to questions on the Advocate Mohammed Abduroaf Facebook page. It is streaming on a few pages, Our Lawyer and the Child Maintenance group. Therefore, please, if you want to pose a question, do so on the Advocate Mohammed Abduroaf Facebook page. A quick way of getting there would be to type into your phone or your device www.abduroaf.co.za/live. It will redirect you to the link just above that, meaning the Facebook page of Advocate Mohammed Abduroaf, which you can see on the screen. Therefore, please pose your questions. I'll be happy to answer any of those questions live and interact with you. Unfortunately, I advertised this video a bit, not too late, but in close to an hour. I'll try tomorrow or Thursday to advertise it a bit more sooner, maybe the morning or early afternoon. There is a webinar tomorrow at 5 o'clock on the issue concerning gender-based violence, an important topic in South Africa. I have with me Susan Larkin. She's a gender-based violence activist and also a school fees activist, as well as a victim of gender-based violence. So she can also enlighten us on that topic. However, today we're dealing with the issue concerning child maintenance. So before I start with the issue, please remember you're welcome to pose questions. However, at the link above, I think you can see it over there. Pose a question via Facebook. Visit facebook.com/Advocate Mohammed Abduroaf/live or use a redirect link. Today's topic will basically deal with the issue concerning how do I prepare myself for a child maintenance matter and inquiry. And I will emphasize this point as much as I need to. Please do not go to the maintenance court or start a maintenance process with the assumption or the presumption that the maintenance courts are on your side, or they're on the father's side. They're not on anybody's side. When you go to the maintenance court, there is an obligation upon you to be successful on your case, to prepare accordingly. Do not go to the maintenance court and expect them to ask you the relevant question, ask you for documentation, expect them to understand your documentation, expect them to sympathize with you. That is not law. That's emotions and that's feeling sorry for somebody. That's not how the law works. If you deal with a maintenance matter, and this before I'm going to the nitty-gritty of it, when dealing with a maintenance matter, please understand the obligation is upon you to ensure that you present everything correctly in order for you to be successful with the case. Obviously, someone that does that goes to the maintenance court, prepares the documentation very well, prepares the arguments very well, does the necessary research, comes to court prepared, would get a better outcome and a better result than someone that goes to the maintenance court and expects the maintenance court to feel sorry for him. With a long story that the father's not paying child maintenance, I'm struggling, which is correct, which is true, but that doesn't assist the maintenance court in the inquiry. It's the same way if somebody is trying to, for example, dress you, not feeling well, and you're fighting that person. The same way here. In order for you to obtain the best possible results out of your maintenance inquiry, out of your maintenance hearing, you yourself need to be ready to put an effort into your maintenance case. You can have the best of lawyers, the best of attorneys, the best of advocates. If you do not put an effort into your maintenance case, the energy will not be there and your results will not be as it should be. Now let's start. The first thing you need to do, you need to know that in order for a court to make any maintenance award, determine any maintenance amount, you need to first determine what the needs of the child is. You cannot go to the maintenance court and thumbsuck and say, I would like to get 100 rand, 200 rand, 300 rand, 1,000, 10,000, whatever the case may be, but your foundation is incorrect. You say, I need that because I think the father can afford it, the mother can afford it, he's rich, he should pay. That logic doesn't work. It will bite you later. The logic which you apply in a maintenance inquiry is, what is the reasonable needs of the specific child? What is the child accustomed to? What has the other party always been paying for the child? What is fair and reasonable? But number one, what are the needs of the child? You need to know that. So you need to know, firstly, what does a child cost on a monthly basis to survive? And the simplest way of doing that would be to work out on a Monday morning, the child wakes up. He or she has breakfast, lunch, supper, snacks, whatever the case may be. You need to work that out. So on a Monday, the child costs so much money. On a Tuesday, Wednesday, Thursday, Friday. Friday, the child goes to extramural activities. The child does this, the child does that. So you work out exactly to the point how much the child costs. A very useful tool would be a spreadsheet. Yes, of course, it's difficult to work out how much the child spends on cereal, but you can work it out. It's not impossible. You work it out. You buy cereal on a Monday. The cereal is up by the Friday. The cereal cost, let's say, for argument's sake, 10 rand. So you divide that 5 days by 10, so it costs 2 rand per day. So you work out the cereal cost. There is only so much items which a person, uses on a weekly basis. It might be a lot, it might be a little, but there is only so much. Therefore, you need to ensure, and I'll be very serious about this, you need to make sure that you work out to the cent how much a child generally costs. The least you can do is work it out based upon what the child consumes. More or less, but you need to have some type of amount. It will be improper and incorrect for you to thumbsuck an amount. The reason why I'm saying so is the other party from whom you're claiming maintenance from has no legal obligation to maintain you. There is no legal obligation. What if you remarried, you have somebody in your life, you're earning your own money? There's no legal obligation for him or her to maintain you. His or her legal obligation goes to the minor child. So that's that. And he should not pay you 1 cent more or 1 cent less than what you are entitled to care for the minor child. Therefore, you need to properly work things out. I like spreadsheets. I use it for my business. I use it for this. I use it for that. And I advise my clients to make use of it as well. It's very easy to assist you in obtaining the actual amount which a child costs. So you work it out. The child is 2 years old. The child uses formula. If the child does use formula, the child eats this. The child uses nappy, these type of diapers, these type of creams, these type of colognes, whatever the case may be. You work it out. I buy it once every 2 weeks. Get slips. Your slip should be able to explain it all to you. Yes, you might say that grocery bill, I cannot work out exactly how much a child costs. But if you cannot work it out, how do you assist the court? That's a question I have to you. How do you assist the court if you yourself cannot work out this amount? What does the court do? Disregard the amount? So if you cannot work out what a teenager eats on a monthly basis, what do you expect the court to do? The court clearly can't work it out. Or must the court thumbsuck? Or must the court just give you a lower amount? And you can't thumbsuck an amount. You need to specifically stipulate. Therefore, do the specific research. That is why I always advise clients, the maintenance matter will be in the maintenance court in 2 months' time or in a month's time. This is your time to prepare yourself for the maintenance inquiry, to prepare your documentation. So I think you're getting what I'm saying. The same, for example, regarding school fees and extramural cost. You need to outline it specifically. Those are a bit easier to work out. Regarding the issue concerning rental, the court might apply their own formula to it, but you need to specifically say, and it's a difficult thing to work out, but it needs to be worked out. You need to say, my rental for the month costs 1,000 rand per month. And I always use round figures. I'm not trying to discriminate against anybody. Some people's rental might be 1,000, some people's rental might be 50,000. But my rental for the month is 1,000 rand per month. But in my house, I have my new husband. I have 2 new children, which I got now when I remarried. And at the same time, I have the minor child, which the other party has to pay maintenance for. So you work it out. So I have my formula. So you must have your own formula. You must stipulate. Okay, the rental is 1,000 rand per month. There's 2 adults. We take the adults out. There's 2 other minor children living in the home. And there's 1 minor child. So there's 5 people living in this house. A fair estimate, based upon what you might say, is a fifth or 200 rand should be allocated to the minor child, because he uses just as much space and just as much amenities as other kids may be using, or the adults may be using, whatever the case may be. But you have a formula, you have an approach to it. You can't say, I want 500 rand per month, or you need to know exactly what you're asking for. So if you do stipulate 200 rand for that specific minor child, and you think it's fairly reasonable, let the court play around with it. Let the court maybe advise you. The court might say, no, man, I feel that maybe 400 rand should be reasonable. Or the court might say, no, 150 rand is reasonable. But you are going to court with a plan, as opposed to stipulating to the court that my rental for the month is 1,000 rand per month, and that's it. And then later on it comes that there's a husband, there's 2 new kids, and of course a minor child. So therefore you need to go to court with a plan. And it's very easy to work out the plan. You need to work out the basics. The child has educational expenditure. The child needs food, clothing, accommodation. And there are obviously the other type of expenditure like petrol, allowances, books, and so on. But you need to unpack that. And you need to do it. You can pay a lawyer to do it, but the lawyer can only do it as well as how you present it. Therefore, I always give my maintenance clients homework. I tell them, and I don't tell them to email stuff to me. Do not email me anything. You need to sit down. You need to sit down with me and explain to me exactly how you've worked out the relevant expenditure. The same with the payslip. I see many payslips. And sometimes I receive a payslip from someone. It takes me about 5 minutes to first understand what on earth is happening here, because I'm not familiar with this payslip. They use, the specific company uses certain codes. They work out certain leave in a certain way, and so on. But ultimately, I might be able to understand it, I might not be able to understand it. My client will come see me and she say, no, advocate, this is what this payslip is. This is what that means. This is how the pension works out, and so on. This is medical aid, and I thought maybe that was something else. This is actually a policy that's been deducted from the pension fund. This is from the salary slip. I am an advocate, but I look at this document, I have my own perception. Now imagine this specific mother or complainant or father just files a payslip, gives it to the magistrate and saying, this is my payslip, or this is the father's payslip, and expect the court to make a decision regarding that. Obviously, the court will look at it the same way as I looked at it and not understand it. And if the court does not understand, the court will just presume. How will the court know that that is a pension payout or pension amount, pension payment? How will the court know that that is medical aid? Because they use different type of codes. So therefore, where I'm going to with this is, if you are presenting a pay slip as evidence in a maintenance matter, attach to it an explanation document. That's what you do all the time. So you maybe reference next to the pension contribution. You say maybe 1, and you have another page attached to it, like an index, cross-referencing, and say that's pension. Holding in mind what I mentioned earlier on, do not for 1 second expect the maintenance courts to think on your behalf, to find in your favor. You need to present your case, and you need to present your case in the best possible and the most logical way. I have a question, and I will stop at that point. I think I'll have to deal with these questions, and we can proceed from there further. The question goes as follows. Does my lawyer speak for me, or do I speak for myself? An important question. Your lawyer is not a party to the proceedings. He does not live in your home. He never met the kids. He doesn't know what the kids cost, and so on. Your lawyer is your mouthpiece when it comes to the procedural aspects. He asks you questions, but he cannot provide evidence. He can provide arguments at the end, but remember, he cannot provide evidence. He did not. So I use a simple example in a motor vehicle accident. He wasn't there. You were there. You witnessed the accident of happening. He can't come to court and say, Judge, Magistrate, this is what happened. Then the Judge and Magistrate will ask the specific lawyer, sir, were you there? Now, how can you say that? You're not even under oath. Therefore, in a maintenance inquiry, you have an attorney to pose questions to you, to address a magistrate, and so on. But at the end of the day, when a decision is made, it's based upon the evidence which you have presented, either an affidavit, if it's relevant, alternatively, the oral evidence on how this maintenance matters takes place. The lawyer can't say, Your Worship, my Lord, it will generally be a maintenance court, Your Worship, the minor child cost 500 rand, whatever the amount is. He cannot say that. He can say, my client will testify that the minor child costs 500 rand per month. However, the client still needs to come on the witness stand and testify it. If the client does not testify that the child costs 5,000 per month, it's just words which the lawyer has uttered and it means nothing. So I hope that answered that specific question. The next question is as follows. Hi, my ex is a drug addict and we have been separated for 5 years. I'm in the process of claiming full rights on her in the High Court as he is unstable. He is jobless and pays zero support. Is it worth even going to the maintenance court? His family has money but all tied up in trust. How does court handle the situation? If the father really does not have any money, and I say this with respect to everyone, if you really do not have money and you really cannot afford to pay child maintenance, you do not have a job and you do not have money, you might obtain money in a few months' time, but now at present there is no money. There's not much you can really do because the person does not have any money. And it's very sad. Then, obviously, I would advise you to approach his or her parents. You climb the ladder. And that's what I advise you to do. You have mentioned in a question that the money is all tied up in trust. That's fine, because once the inquiry takes place, I am certain that these specific parents obtain money from the trust. So you can obtain the bank statements, etc., and you will pick up that they are claiming money from the trust. If they are not, too bad, but I would never advise somebody to not proceed with a maintenance matter based upon the possibility of, where there is money, but on the possibility of the parties playing dirty, not disclosing, and so on. So with regard to your question, I would actually advise you proceed to the maintenance court, at least have an inquiry, at least call the grandparents in, and the father, of course, in as well. And based upon that, and based upon how the court maybe advises you, or maybe what your attorney advises you, then you can decide whether or not to proceed or not. But I would advise you to proceed. Thank you for that question. If you have any further questions, please feel free to post it. If you want to add to that specific question, you're welcome to do that. Additional question. When parenting plan says that father is responsible for reasonable expenses towards primary, secondary, tertiary, and tuition fees, does it only mean school fees, or does it mean everything related to textbook, exam fees, stationery, school uniforms, etc.? Now, this is a problem when it comes to parenting plans and the use of the word reasonable. Dispute always arises later on if the parenting plan is not well drafted. If stationery, textbooks, exam fees, and school uniform were to be included, it needs to be specifically stipulated, or the parenting plan needs to specifically state the father will only be responsible for these specific items, and the following items are not included. My answer would be, I would say, it is reasonable expenses towards the primary, secondary, tertiary, and tuition fees. Does it mean school fees as well? I would say yes. Of course, it applies to school fees. Does it mean everything related to textbooks? I would say general textbooks, yes, of course. Exam fees, yes. Stationery, yes. School uniform, that's a difficult one. Because in my view, I think school uniform should be included, but it refers to educational expenditure. Generally, that applies to, the educational aspect of it, not necessarily the clothing. like sports clothing and so on, and school clothing as well. It should have actually been stated in the parenting plan that school uniforms are applicable as well in the maintenance arrangement. Therefore, if you, as a person that entered into this agreement, had that understanding at the time of signing this parenting plan that school uniform was also included, and that was your understanding, then I will stick to that understanding, and I will proceed with that, and I will say that's my understanding, reasonable expenses towards primary expenditure, and argue that reasonable expenditure regarding schooling includes school uniforms as well, because that was your understanding. If it was not your understanding, then you have to make a decision regarding that. But in my view, I would say school uniform, that needs to be specifically stipulated as another item within the educational arena. Then the same person goes further. He asks the following: furthermore, if the child has been attending a private school for the last 12 years, can he suddenly want to move her to a public school because the court agreement is reasonable school fees? I don't think that in the minor child's best interest to move a child from a private school to a public school. Not to discriminate between any schools, but if there's a change in the type or the manner of education accepted for the minor child, and it will not be in the minor child's best interest to move from a public school to a private school, I would believe that would not be the minor child's best interest, and the minor child should remain in a private school. I would presume also that the private school costs a bit more money, unless, for argument's sake, the specific parent cannot afford, can no longer afford a private school. But in my view, the minor child should remain in the private school. The next question: if the father moves 3 hours away from the area of the child's primary residence, does the mom need to drive 6 hours there and back, or is the father's responsibility to travel as he decided to move far away? My view, the father has to travel, not the mother. It's a quick one. How do you arrange an appointment with a family advocate if they don't respond to lawyers' emails from the appointment? As we're going through the lawyers, I would say speak to the the office of the senior family advocate, Mrs. Ibrahim, at the Family Advocates Court if it's in Cape Town. If you're in a different province, speak to somebody else higher than the Family Advocates office and lay a complaint. They have to attend to your inquiries. I know it's COVID-19 and things are a bit more difficult and complicated. However, they need to attend to you. So one of two things: speak to somebody senior, a complaint person that you're allowed to complain in the in the Family Advocates office. Alternatively, find out who's the head family advocate and lay a complaint to that person. If it still doesn't work, then contact the Provincial Department of Justice and lay a complaint by them. The person that posed a question early on says, thank you for answering my questions. You are welcome. And we have another question: can a High Court application expire? Usually the High Court application will stipulate that if the matter is not opposed, the matter will be enrolled on a certain date. So I'm applying my law of civil procedure here. If the application has been postponed indefinitely, so technically it cannot be expired, it has been postponed indefinitely. If the application was made and nobody done anything about it, but there's always a default date on it. If the matter is not opposed, it should be set down. So it's a difficult question to answer. Technically, I would say if the fact has fallen away and you made an application and it's no longer relevant, I can't say it expires, but I can't see the use of proceeding with it. If it is relevant and it's quite some time back, however the matter was postponed indefinitely, then of course you can set the matter down for further hearing. I have another question, another live question. Can you speak to the High Court even if you did not instigate the summons? I think then you will be the defendant in the specific matter. I don't understand the question too well. Yes, you can speak. You do not need to have a lawyer in any legal proceedings, and therefore, if you want to make inquiries in the High Court, anybody can make inquiries in the High Court if it's your matter. I, however, do know that in the High Court, because of COVID-19, things are a bit more challenging. However, you're welcome to, and if it is your matter, they will give you access to pose questions or to attend to your matter. So you're welcome to do that. If there's any further questions, please feel free to post it and I will answer it. Oh, the person says, thank you. That's all for today. Okay, so next time we can add some more. You're always welcome to post questions and I'm always happy to engage with you. We're moving back to the issue concerning the maintenance, preparation for the maintenance hearing. Remember, we have not yet proceeded with the actual maintenance inquiry. That will be done at a later stage. I'm still on the issue concerning preparing yourself for maintenance inquiry. Once again, ensure that you can prove your case. It's very important. Many times you approach, you're appearing before the maintenance court, or you're dealing with a maintenance inquiry, and let's say, for argument's sake, the father got primary care, and he approaches a maintenance court and he asks for a big amount of money. Let's say he earns for the month 2,000 rand per month, but he wants 3,000 rand per month as child maintenance, which could be legitimate. There could be grounds for that theoretically. But then you go through his bank statements and through his documentation which is provided. Then you work out, but clearly logically, based upon your request, before going into the needs of the child and the expenses of the child, you come to the conclusion that it's impossible, because your salary is 1,000 rand per month or 2,000 rand per month. You're saying the child costs 3,000 rand per month, but your bank statements are all, 0, 0, 0. It should have been in overdraft. You should have been highly in debt. So clearly, on that basis already, you can work out that someone is lying, someone is not disclosing the proper facts of the matter. Furthermore, when you're looking through the minor child expenditure, then it shows that the minor child costs, for example, 3,000 per month. But it illogically doesn't make sense based upon what you're earning and based upon what your expenditure, your personal expenses are as well, and the amount of debt you're in. It needs to make logical sense when you're approaching the maintenance court. The maintenance officers are obviously well trained. They deal with these type of matters on a regular basis, and with the magistrate. Therefore, when preparing a documentation, it's important to know that there is a difference between what you are currently expending in relation to the minor child, based upon your current income, and what you would ultimately want to spend on the minor child if the other party could assist you. Therefore, if the minor child did not obtain any new school clothing, and for the last 6 months or last year, you only spend 1,000 rand per month on the child, which only entails basically basic clothing and food, but the child required much more. Now, in such a preparation of documentation, I would advise clients to say, this is what the child is currently costing. I earn 2,000 rand per month, the child costs 1,000 rand per month, and this is how I work out my income and my expenditure and so on, and this is how I can afford to pay for the minor child expenditure. However, the minor child requires the following. So you have a separate spreadsheet for that. The minor child requires this, that, and the other, but the other party is not assisting, and had the other party have assisted, I would have had enough money to pay for the additional expenditure which a minor child requires. So you go to court with those type of information, that type of documentation, in order for you to make life very easy for the maintenance officer or maintenance magistrate. And believe me, when you're on that witness stand, when you're being cross-examined by the other party's lawyer or the maintenance officer or whoever it is, or being asked posed questions by the maintenance magistrate, you can go blank. But if you have your documentation in front of you, which you have prepared, which you understand, and which you can logically present to the maintenance court, life will be much easier in the maintenance court. You will see that you will fare much better than the other party. They come to the maintenance court with a list of income and expenditure, and hoping that the maintenance court will find in his or her favor. Okay, let's go back quickly to the questions. The person says, yes, as a defendant in a high court case, my ex is challenging my custody. Yes, of course, you're welcome to approach the high court, speak to the clerks of the court, try to obtain a copy of the court file, and so on. If you are underrepresented, remember, you're your own lawyer, so you can, litigate your own case. You're welcome to do that. You should do that. So that answers that, and I hope we'll be seeing in the next few minutes many more questions posed on the issue concerning child maintenance. So let's move on. This is how we're discussing the preparation of a maintenance case. I believe in spreadsheets. I believe in outlining information, unpacking information. I have a lot of highlighters in my office, a lot of scrap paper where I can paste receipts on. How do you prepare documentation when it comes to groceries? It's easy to work out the school fees, it's one slip. It's easy to work out extracurricular activities. It's easy to work out rental expenditure. But groceries seems to be a problem. And groceries is the most difficult one to prepare for, not the most difficult one. Two different scenarios. You need to have a lot of scrap paper. Maybe make use of clear paper because it will have to go to court. So you take your receipts. You got all your receipts from the first of the month till the end of the month for you and the minor child or whatever expenditure you have. You paste it accordingly. So the general groceries at Pick n Pay, at Checkers, at ShopRite, wherever it is, you unpack it from the first of the month till the end of the month. Start highlighting, or you put numbers next to certain items. Then you have additional paper or a spreadsheet initially where you type out. So you say groceries, you highlight, these are for food, this is fruit, these are vegetables, these are cereals, these are spices, whatever the case may be, and you unpack it. And you unpack it in a different page where you stipulate these are expenses for the minor child, these are expenses for me. So an entire month, we can work out exactly or close to exactly what was spent on the minor child and what was spent on the rest of the family. It can be difficult, but it needs to be done. And groceries is the one aspect which you do not want the court to thumb suck. If the court has their own, view on it, if you know your minor child costs, he eats a lot or she eats a lot, and it's lockdown now, they eat much more at home. We all know that. You know your child eats a lot and your child consumes a lot in the house. If the use are stipulating that the minor child eats 500 rand worth of food, which I know is very little, but let's say, for example, that is the case. He eats 500 rand worth of food per month. You would not want the maintenance magistrate to rule that the minor child only eats 200 rand per month. Just because you did not spend enough time unpacking and proving to the maintenance court how much your child costs. So if the maintenance officer and maintenance magistrate tells you, isn't that a bit too much? 500 per month? Say, no, it cannot be enough, magistrate. It cannot be enough, attorney, because this is a proof. If I work it out, look through it, I buy cereal 6 times a month. That is what the child consumes. I do not eat that cereal. The child eats that cereal. I buy the following plates of food. So the grocery bill for the rice and everything comes to 1,000 rand, for argument's sake, for food now. We talk about meat and fish and chicken and all those things. This is the grocery bill for the month. We 5 people in the house. The minor child eats just as much as an adult. Clearly, we should cut the grocery bill into 3 because nobody has a preference in the home. Nobody eats more than the other person, or nobody eats different type of food. So I do not buy steaks, which could be expensive, but the minor child does not eat the steak, and I add it to the big pot. Because remember, as I mentioned earlier on, there is no obligation on the parent who is paying maintenance to maintain the person who is maintaining the child. There is no obligation. His or her obligation goes to the minor child. Therefore, it's very important that you unpack it very well. You do not want the court to have to guess. And the court, you need to convince the court, and the court will definitely be convinced if you outline and explain that to the court, because the father, for argument's sake, in this scenario, does not live in your house. He doesn't know what the child really eats. He might know, I'm using this a separate scenario here. You're the one that feeds the child, that cooks for the family, and so on. Therefore, you are the one that can explain it. But you need to explain it with some documentation. Otherwise, the court can, thumb suck and say, I think 500 rand a month is too much. The court might say, I had children 20 years ago, and they never ate so much. That was 20 years ago, and things were different at that time. But if you have documentation, receipts dated December 2020 until January 2021, and you highlighted things, you highlighted items, you work things out, obviously you spend money on it. And even better if you can have receipts for the last 3 months unpacking this. It might be 100 pages of documentation. But remember, if you present that to the maintenance court, life will be much easier for everybody. I have additional questions over here. It says the following. Does a criminal record expire after 10 years, or can it still be used in a court data a criminal record for drinking and driving? They call it expungement of criminal records. It depends on the criminal record. I think you have to apply to the relevant department, I think to the police, whoever the case may be, to have it expunged, to have a criminal record expunged. Drinking and driving, you will have to confirm with that. I'm not such an expert on criminal matters. This is basically family law. But of course, like theft, murder, robbery, those sexual offences, of course, that wouldn't follow. That will obviously remain till the end. But we might refer to more petty type of crimes. So you'll just have to verify with the police station or the relevant department. Another question, the dad tried to commit suicide, drug overdose years ago. However, does this still need to be mentioned in court, and what will it be viewed as? So this is a custody question which I will entertain. If it's relevant, it's relevant. So a custody dispute generally will apply to one parent once they have contact with a child, or more contact, or one parent wants to hold the child, keep the child away from the other parent, and so on. Then the question is, do we bring up information regarding what happened years ago? We can bring that information to the fore if it's relevant, if it will affect the court's decision. But if the person had drug overdose, the person many years ago, the person went to rehab, the person is clean for the last 5 years, I can't see it being any relevant. I think you're wasting your energy and your time mentioning things that will not really assist you. This is my motto in legal matters. This is my approach. The courts are human, the other party is human, everybody has a certain tolerance level. When you present arguments or present documentation or evidence to the court, I like to use a 40-page principle, or what I've coined the 40-page principle, whereby you get 40 pages to present your case for custody, for guardianship rights, co-custody, and so on. That's what you get for 40 minutes. If you're going to waste 30 of that pages bad-mouthing the other party, mentioning things about the past, which is all irrelevant, you're welcome to do that, but you've wasted 30 pages doing that. And then later on in the 10 pages, you mention relevant information. As opposed to a party who spends 30 pages of mentioning only relevant information, because that is what the court has the energy for and the time for. And the other 10 pages he uses on other aspects, maybe introductory issues, etc. He will be much more successful than the party who mentioned a lot of irrelevant information. So therefore, if the person had a drug problem years ago and it's rehab, etc., I do not see how it's relevant to a custody matter today. It could possibly be, but I do not see how it's relevant today. If the person is currently a drug user, an alcoholic, and so on, the question must still be posed as to what effect that has on the minor child, and how can we facilitate contact arrangements considering that. Should contact be supervised? Does this person only use these specific substances on a Sunday evening, on a Saturday evening, on a weekend? Does it we only want this parent to collect the minor child every Monday morning and drop the child at school? Does this person's alcohol addiction apply to that specific mornings in the morning, or does it only apply to weekends, etc.? You still need to use your mind, your brain, your intellect when dealing with these type of matters. We cannot, for example, have a checklist and stipulating the father was a drug addict years ago, automatically he has limited contact. Alternatively, the father uses drugs at present, automatically cannot have contact. It might be the ultimate decision not to have contact, but it also might be better for the minor child to have supervised contact. Or it might be irrelevant in the sense of that the minor child only has contact with this person once a month in a public space, in a shopping mall, where the minor child will generally be safe. So I do not answer these type of questions in isolation, in the sense of giving a general answer to a specific type of scenario. I would like to look at the matter holistically. So when I deal with these type of custody matters, you need to look at all the facts, because at the end of the day, whatever you present will go before a judge. And in the same way, which I mentioned earlier on, you need to prepare your maintenance case The same way in a custody matter, you need to prepare your custody arguments. It needs to be logical. And at the end of the day, the court will look at what's best for the minor child. So you're welcome to pose any further questions, but that's my answer on that. I might be wrong, but that's my answer. And another question goes as follows. If the father has remarried, does his wife need to give her bank statements or slips as she says she's paying all the child's expenses, as the father can't pay for it, as he's already paying my child's expenses, even though when I look at his expenses, he has more than enough to support both. So the question is, is there obligation upon a step-parent to disclose his or her bank statements? No, there is no legal obligation. However, if the parties are married in community of property, maintenance gets paid by the joint estate, of course. So if the husband is unemployed, but he obviously has a legal obligation to maintain the child, but he's unemployed, but his wife is wealthy, but because he got married to an income into property, he becomes wealthy as well. So she may be earning a huge salary, which ultimately belongs to the joint estate. It belongs to both of them. Therefore, one can look at it from that specific point of view. Because he owns her money as well, the maintenance will have to come from basically both of them. Or his contribution for the maintenance will have to come from a joint estate, which he owes half of. So the maintenance court can technically ask, in a given scenario, for the spouse to provide her banking details. Good evening, sir. Yes, good evening to you as well. Thank you for joining us. The question goes as follows. Is it worth it fighting for maintenance for over 10 years as she simply just refuses to pay? And if I do go, whatever work she has, she leaves it as she is aware of the garnishing order set out against her. You see, this is the challenge I have with answering those type of questions. If somebody really does not want to pay maintenance, the person doesn't want to. The person doesn't mind not working. The person will try his or her utter best. So even if you take the person, to the criminal courts, send lawyers letters, this person's attitude is, you can do what you want, or I will not pay. And those are the worst type of defaulters of maintenance, because they will make your life extremely hard. If they do not the maintenance court, they do not pay, etc. You need to make a decision. You have a specific person in your life, if it's a mother of your child. Do you want to continue claiming maintenance from this person, which you know maybe that it will be unsuccessful because this person will just leave the work, or the person will make a plan of not paying. But if you believe this person in principle needs to pay, and this person needs to be responsible and call to the maintenance court, then I would advise you to make that application. But many parents out there want to pay maintenance, but maybe they do not want to pay as much as they are asked to pay because they have their own versions of how much they must pay. Those parents are fine because the maintenance court can get involved. The maintenance court can, advise accordingly and make the relevant order. But as I mentioned earlier on, if you really do not want to pay, it's like somebody that doesn't want to work. He doesn't want to work. He doesn't mind wearing old clothes, eating old food. That's the worst type of cases, not worst type of people. I will never judge anybody else. The worst type of cases to be able to deal with, because you are fighting almost a losing battle all the time. You go to the maintenance court orders this person to pay, the person doesn't pay, the person doesn't care what happens. So good luck with your matter, sir. But if you ask me if you should make a decision, I would say approach the maintenance court. That will be my decision, and see what happens. Any further questions, feel free to pose. We've got about another 15 minutes to deal with that. Now, let's go on. There's a lot of information which you may require in a maintenance case that will assist you in being successful in a maintenance case. Some of that information could, for argument's sake, be, I don't know, bank statements of the other party. Could be Facebook records, Facebook pictures. For example, the mother of the child who is supposed to pay maintenance says she cannot afford to pay maintenance, but if you look at her Facebook profile, she's always out with friends, partying, wearing nice clothing, and having a good time, which she has full right to do. Everybody has the right to do it, but not at the expense of not maintaining a child. I believe if a child costs 100 rand per month, and you earn R1,000,000 per month and you're paying R100 per month, because that's all the child costs, all the child needs at a specific point, you can do whatever you want to do with your money. Enjoy life. However, if the child costs R1,000 per month and you earning 1,500 per month and you need to give 1,000 towards a minor child, you need to do that, even if it means that you cannot enjoy life. The end of the day is what's best for the child, not what's best for the child in isolation, but what is fair and reasonable under the circumstances. The child requires food, clothing, accommodation, and so on. If the child has all of that and it's reasonable, fine. You may have to work harder, the mother has to work harder, both parties have to work harder. Facebook, as I mentioned earlier on, we're on Facebook now, Facebook Live. Any further questions? Yes, I see some questions. I will answer that shortly. Obtain that information. Don't go to the maintenance court. Please do not do this. Just take out your phone there and show the maintenance officer or the maintenance magistrate. You see, this specific person is partying. That's not how it's done. Go to a printing store, print out the photographs, screenshot it, print out the screenshots, and so on, and that is your information. Go on LinkedIn. If the person advertised his or her position, said, I worked for this company, I worked for this company for so many years, and so on, that is relevant information. Go on Instagram. Make use of social media. That is additional information. If you believe there is relevant information held elsewhere, for example, the other party's bank account, make note of that. Say, while we were together, this person used to have an Absa bank account, a Standard bank account, this credit card, that debit card, whatever the case may be, and present that to the maintenance court and ask the maintenance court ultimately, or make an issue about it, I would like these specific bank statements as well. Because I believe it holds in a lot of relevant information. For example, additional income or spending habits. The person might be using those specific credit cards or bank cards to, to buy things, which things might not be necessary, which could be better used to maintain the minor child and support the minor child. So go to the maintenance court with that. So if you listen to this video from the start, you are thinking this advocate Abduroaf gives these maintenance complainants all this hard work to do. Maybe I should just leave it. Please, I wouldn't do that. I would say this is how life is. You go to court, you go to bed. I mean, if I must prepare myself for a race, a marathon, or whatever the case may be, a distance cycle, I will prepare, I will, train. I'll do what I have to do. The same with the maintenance matter. The same with applying for a job. The same with going to work. It's no different. You take pride in what you do. When you're approaching the maintenance court, go well prepared. Make sure you have everything, all your ducks in a row. So when you appear in front of the maintenance officer, or when you answer questions and you're underrepresented from the lawyer, the other side, from the other side's lawyer, the ex-wife's lawyer, or the mother of the child's lawyer, the father's lawyer, you have your ammunition. Your ammunition is the documentation, your explanations in the documentation, and that is what you can present. How can the maintenance court not find in your favor if you have properly outlined to the maintenance court what the child cost? Only you can answer that. The other party can't answer that. You have properly outlined what you cost. Only you can do that. The only question is what the other party must support. But you went on Instagram, you went on Facebook, you went on LinkedIn, you went on Pinterest, whatever the case may be. You went on these specific platforms and you found out information. You have relevant information that when you were with this person, you have information regarding the person having pension funds, having policies, pension funds, and so on. You have that information, you have unpacked it. So you go to the maintenance court well prepared. Just a note before I end this off and before I start answering the last questions, when you prepare this documentation, please have a bundle of original documentation, payslips, receipts, and make photocopies. I cannot stress more. And also number this documentation, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, till whatever it is, or A1, A2, whatever. So life will become easier. Have an index to make life much easier for the next person. And you will start understanding and seeing that you are becoming more confident in a maintenance case. You will feel that. You will literally feel that you are getting somewhere. And generally, like for me, as an advocate, when I get a new brief, a new case, and I know nothing about this case, and I don't understand the law so well because the law has developed, or it was many years lost, I've argued this matter, dealt with a matter like this. Obviously, I'm nervous, I'm apprehensive, and so on. However, as I get into the case, I start preparing, I look up the law, and I get more prepared, I become more confident. And life becomes a bit more easier, especially where that is concerned. And the sooner I can get myself ready and get my ducks in a row, the sooner I can get this anxiety away. So if I get these type of briefs on a Friday afternoon, usually spoils my weekend, because usually on a Monday morning I have to start preparing. So my brain starts working the entire weekend. Oh, I don't know this, I do not know that. But Monday comes, I prepare, and the rest of the week is easier. Make photocopies. Very important. It's very important that you go to the maintenance court with a set of documentation for yourself and a set of documentation for the maintenance court and a set of documentation for the other party. If you cannot afford the photocopies, at least go to the maintenance court with one set of copies of the original, which will be given to the maintenance court. It's very important. The maintenance court could possibly make a photocopy of the specific copy, but you have your copy. The worst you can do is approach the maintenance court with all the original documentation. Sometimes it's in a non logical fashion. It's a pay slips and a receipt and so on. The worst you can do is to give that to the maintenance court. You go home, the matter gets postponed for 2 weeks. What do you do? What do you prepare? How do you prepare yourself for the maintenance court? You go to a lawyer for whatever reason, instructing him to assist you. With the documentation notes in the maintenance court's file, it won't assist anybody. You need to have a copy of your court file. The same with me. If I'm representing a client, there's a copy of the documentation in my office, the maintenance court's file, at the other party, at my attorney, wherever the case may be, there are copies of this documentation. Do not be, as I can say, economical. Try to save a few rands by not making photocopies. You need to do that. So that's basically regarding the documentation, the bundle. And please, it's a lot of work, but we all have to prepare. That's how life is. You need to go prepared in anything. Applying for a job, a maintenance inquiry, a domestic violence inquiry, whatever the case may be. It's not a lot of work, it needs to be done. Okay, we have additional questions over here. You see the following. Thank you for your info. I asked a mere 800 Rand per month since 2014. I think my mind is made up. Good luck, sir. I hope justice prevails. Additional question. How do you know if the other party has more than one account and not revealing it? Yeah, so what the simplest way would be is to ask the maintenance officer to subpoena various banks. So we know the normal banks, Absa, Standard Bank, FNB, Capitec. Then there's other type of banks, Investec Bank, and but more expensive banks. The maintenance officer will have to send subpoenas to all these banks and see what they have to say. You can also maybe subpoena SARS and see what SARS has to say. Obviously, you can do an ITC check on that person or credit check on that person. The maintenance court can do that, and they can obtain relevant information regarding credit applications and credit cards and so on. It's a bit hard, but if you catch that person out, if the person tells the maintenance court, I do not have those both bank statements, and it comes and it reveals later that those bank statements are there or those accounts are active, it won't be in that person's best interest or in his or her favor. I would presume they wouldn't lie on that. They most probably would mention they close those accounts. But the quickest way would be to subpoena all the banks. It can be very expensive also. If the person is a salary earner, it might be a better voice of energy because, he earns a salary of 100 Rand per month. It goes in his bank account. That's it. If the person is a business person, it might be different. It might be useful to look around and find out if they are on other bank accounts. Another question, if the court can't find your maintenance file, do you need to reapply? No, you don't have to reapply. They should find the file. But if you've been missing, you must probably just have to complete the maintenance application form and try to get hold of all the documentation again. That is why I think it's important to mention it again now. Photocopy all your documentation. So if they lost the maintenance file, you still have your file, which is a duplicate of the maintenance court's file. Done. Another question, and that might be our last question. This is a very sore point, but can a summons Can I summons her father to court? Yes, you can summons her father to court, the maternal grandparents of a minor child. For maintenance, you can do that. The court will obviously have to follow certain type of proceedings. For example, first proceed against the mother, and then against her parents. And obviously, your parents would also have to be brought into the mix if necessary. But if you are already contributing on the paternal side, I cannot see why your parents should be brought into the mix or into the picture. The maintenance court will have to determine what is fair, just, and equitable under the circumstances. Yes, that is it, because it will be wrong. For example, her parents are super wealthy and your parents are wealthy, but they are paying the majority of the child expenditure because you are not that wealthy. So obviously your parents should have come to the mix as well. The maintenance court will figure out a way what will be just and equitable under the circumstances. Ladies and gentlemen, thank you for joining me on this Tuesday evening. We had a very successful webinar. There were many questions posed, and I tried my best to answer all of them. And I think we have concluded, and we are a bit more knowledgeable on the issue concerning preparing yourself for maintenance inquiry. That was only step one, getting the documentation in order. And lastly, I will say it one more time, it's a lot of work, but it's work. So if it means spending every night an hour, do it. Do not be despondent because of all the things you must do in order for you to appear before the maintenance court. If you ask me now to do a 10-minute webinar on a topic I do not know, and I might spend 2 days preparing for that webinar, I will have to do it. Otherwise, how can I present that webinar or those 10 minutes on a topic I do not know today, but I will know it tomorrow and I will know for the rest of my life. Have a lovely evening, everybody, and I hope to see you live soon. Tomorrow it's gender-based violence, but on Thursday we will have another one of these webinars, but we will advise you earlier on during the day what time it is. I'm just in court in the mornings, and usually court ends a bit earlier, but I do not want to commit to that time now. Sometimes the judge will be a bit longer. Have a lovely evening. Thank you very much.